And before we get started, we also want to confirm that at no point do we see ourselves as experts in all of these changes that are going on. We're just going to speak from our perspective about what it could look like in our world and hopefully help you to work out what it looks like in your world. But we're not here as experts. We're not the Attorney General's Department. We're not the Mediator Standards Board. We're just here as Bobbi and Linda to kind of give our views on it and let you know where we sit with that. So my name's Bobbi Reilly. I'm one of the Directors of Global Training and Professional Development. I know many of you. For those of you that don't know me, I am NMAS or AMDRAS accredited soon, and I'm also an FDRP, and I've been in the industry for a very long time now, not as long as Linda, but yes, I consider myself to be been there for quite some time. So I'll hand over to you, Linda, to introduce yourself.
Thank you. Yes, I think some names look very familiar.
Yeah.
My name's Linda Kochanski, and I have been in the business for a bit longer than Bobbi, but that's because I'm older as well. I'm also AMDRAS and FDR. I suppose I do bring a little bit of gravitas here with the I'm was a director on the AMDRAS board from 2016 to last year, and I am still involved in a couple of the committees in this. It is a very exciting transitional period. So that's my background. So as Bobbi said, we're not here to be experts. We're here I can talk a little bit about what I know is happening from one aspect, and both of us are FDRPs, and have gone through all the changes in the regs, etc., and just share what we know and share the discussions we've had. So all good.
Absolutely. And there has been so much change. I think probably in the last 2 years, the amount of change in our industry has been huge. The last lot of change really was back in about 2009, when they brought in the extra certificate and some more extra DV legislation and things like that. But this is actually industry specific big changes that are happening to us and have been happening for some time. And there's still some changes coming as well, I believe. So really exciting time. And I think it's really good for the profession to really, I guess, set itself in a really stable footing in the industry to hopefully help us to grow.
I think it can be a little confusing too, Bobbi, because we've got the two parallel processes happening at the same time.
Yeah.
AMDRAS, coming into being, even though it's been coming and coming and coming, but also now with the FDR changes and some linkage, but some they're very parallel. I think at the moment people are going, what are we going to do? How are we going to do it? When do we have to do it? So I suppose the first thing, if I can say, is look, just relax. We've got time on all of these things. So nothing has to be done tomorrow. Things will happen. I mean, FDR changes will occur, but there's a lot of the FDR changes that may cause concern. You've got some time, and we'll talk about that. And certainly from a AMDRAS perspective, and I'll talk to that shortly, is that you as the mediators, you've got time because the members and your approval providers and your training providers, they have to do all the hard work at the moment, and then that will filter down to you. So try not to be overwhelmed. I know it can be because you've got this and this and this, but it will all fall into place. Give it time.
Yeah. And I feel like I've noticed on social media and through email threads, etc., that there is a lot of uncertainty for people about exactly what it's going to look like. But yeah, I would agree, Linda. I think everything will just occur. And if we just sit back and wait, we will be instructed by the professionals of exactly what we need to do if we need to do anything. But I guess with the AMDRAS, it really is about just automatically transitioning over. I don't think there's going to be any dramatic change in that initial first step. Would that be right?
Yeah, look, maybe we kick off with AMDRAS because it's probably the easier one. And many of you may be AMDRAS or at the moment, depending on where you're, let's talk acronyms, isn't that awful? But you've probably always all heard of RMABs because you've been involved. Well, they're transitioning into what we call RAPs or RAPs, and that's going to be recognized accreditation providers. So they'll be providing your accreditation, they'll be doing all that. Then some of them will be what we call RTPs, and that's recognizing training providers. Other organizations like GPD, we will be only an RTPD. And all of this has got to sort of come into place by the 30th of June this year. So wherever you are accredited at the moment, some, the bigger ones have already been approved. And it's not an easy job. They have to fill in lots of applications, and it goes through a number of committees, and I'm still involved. I'm on a couple of committees, and then it goes to the board, and then it gets ticked off. And because we want to get it right at the first time, so that's why if you are with your RMAB still and they haven't converted or told you you're now AMDRAS, well, that's because it's all happening still. So what will happen is once they become RAPs, then basically all their mediators will become accredited mediators and AMDRAS accredited. When that happens, you can change it from NMAS to AMDRAS, and then basically it's just that overflow. There's a bit of timing lapse about when you might get your reaccreditation. There's some changes to fee structures, but there's nothing going to be major at all with that from what you're doing down, what you're doing under AMDRAS or what you were doing under NMAS isn't going to change. What a lot of people are looking for, though, are the levels. There's accredited mediators, which you'll all become, and then there's advanced mediators and leading mediators, and then sitting on the side are specialists. Now, some of you might already go, oh, I want to be advanced, or I want to be leading because I've been here in so long, I want to tick on my box. Now, I'll start with the leading mediators. Can I just say, just chill, just hold fire, because there's the leading mediator has to have a very specific framework, and they've got to tick boxes, etc. And that, every leading mediator application has to go to the board for approval. And so in that case, what I'm suggesting is just, can you wait until the second half of the year if you're dying to be a leading mediator? Because that's not the priority. The priority is to get everyone AMDRAS accredited, get the RTPs, get everything, all the training and everything ready to be ticked off. So that's the important thing. So leading has a slightly different angle to it. But a lot of you probably are up for the advanced, and the advanced, you've got to have 4 years, so many hours of mediation under your belt. And some of you might be thinking, oh, can I apply to become an advanced because I've got all this experience, blah, blah, blah. Now, the board is looking at that, and the reality is that to become an advanced mediator, there's one more step. Now, yes, I know it's going to cost money to do the practicum certificate workshop, as we call it, but there is real value in it, because the practicum certificate workshop is set up so that you and your peers have 12 hours, you give presentations, you do peer supervision, you get advice on how to might do something different, you get activities. It's a very much, I call it reflection on steroids, because it's the ability for you to really, really show that you understand, and also share and have information shared with you. So, if you are thinking of becoming advanced, it's really just a matter of getting a practicum certificate workshop. Now, again, it's slowly happening. Places like Resolution Institute have just started. GTPD, we will have ours created, but we will create it to meet for our members' needs. So we will look at whether we do it over, I'm speaking, Bobbi's nodding, and we haven't really talked in a lot of detail, but I've been drafting it all up. We'll look whether we do it in 2 consecutive days, whether over weeks, whether, over a weekend. So we will look at it to cater to our members. So what I'm saying again, just wait until the second half of the year. And if you're really keen to become an advanced mediator, there will be that options. I would say come to GTPD and do it with us if you're a member. But if you're wanting to get it, there are going to be the other RAPs and RTPs offering it. But look around, and I'd say that's the way that the board wants that all to be ticked off. The other last one is about specialist areas, specialist mediators. Now that's a unique, and that's going to be coming from your community. Now, what I mean by that is, if there's 150 of you on, not that many, but if there's a number of you that coming from a workplace perspective, and you can see the uniqueness in the workplace, then that's a discussion you have with the board that you could be ticked off with the workplace. For example, I'm just giving, and so restorative justice. Again, that's probably something that will be generated from your community. So if you're a collaborative lawyer, or you're coming from, elder mediation, or you're coming from, restorative justice, as I said, and it was designed to fit for like our own country mediators so they could get recognition. Again, that's a very separate, and that's something that needs to be thought about, that will be generated from the community. But in short, nothing's going to change for you as such, apart from having the ability to go up and down a little bit. You will find, as an accredited mediator, the hours of actual mediation that you have to keep up every 2 years has dropped to 10 hours a year. So it's 20 hours over 2 years, much more manageable in some ways. The RAPs will still have discretion if you're a regional person or you've had difficulty. So, have a look at that. The final thing I'll say before I throw it to Bobbi, or she has questions, is, and this connects in a little bit with the FDR, that we're talking about keeping record of your CPD. You've got to keep it now for 7 years under the FDR, not so much under the AMDRAS. But if you have a look at AMDRAS, and I know it's a document that could put you to sleep, but it is worth having a look at. And I think it's Appendix 4 off the top of my head, is all about CPD and has a CP document. Now, for our GTB members, we've got our portal, we've got all of that, so you can keep a record. But for new people here who may not want to join up with GTBD, but we would suggest you do. But if you don't, I would suggest you've got that document that will help you. So whilst it's for AMDRAS, it could also be used, and that will be a good record because that will be recognised as well. So those are my highlights. Bobbi, did you want to clarify anything on behalf of the group, or?
And I think, Linda, with that, the CPD, and we know that a lot of the CPD that we do is probably transferable over between AMDRAS and FDR. So I think keeping a record one way or another, and the amount of CPD hours in a 2-year period is really close regardless. And I think as a general rule, most of us, just by trying to grow in our practice, would be able to get those hours without any real issue.
Exactly.
Obviously, our members get it through webinars, etc. But I think that, keeping those records, whether it's with us or whether you're using the AMDRAS tool for your FDR as well, I think is really, really important. And I did go on and have a look, and it's really easy to use that document. Great resource. And especially because now we do have to keep them for such a long period of time for FDR.
Yeah, easy to put in a file, have document. And under AMDRAS, there is still all the alternatives. So you don't have to be at a webinar every 20 minutes, or like those of you who are lawyers, get it all done by a certain date. You've got that. Of course,
reading or whatever
all
it is.
our CPDs, that we design that so it does get your hours for you in a year. But like, if there's other ways, like the NMC this year in Sydney, really good opportunity for networking as well as CPD. But you can read, you can volunteer to do role plays. There's a whole section under AMDRAS that I think it's worth having a look, because then it shows you too how your CPD can be gained across a number of kind of modes and structures as well.
Absolutely. And I'm sure that if people haven't looked at the document and aren't aware of all of the different criteria that they can fit it under, they'll be doing themselves a disservice with the amount of CPD they've actually put themselves through in that period of time.
And my last comment, Bobbi, before I hand to you, is do keep your accreditation up, please, because if you're a NMAS accredited mediator and you lapse for whatever reason, AMDRAS is a lot beefier in their assessment. There's not going to be an alternative pathway at this moment. I don't think it will happen. So that if you don't, you'll have to go, your RAP will say either you have to redo the course, or at the very least redo the assessment. And the assessment under AMDRAS is a 2-hour mediation, the whole work, ball and dice, plus a written assessment. Now, we don't want to do that because that adds pressure to ourselves, but I'm saying that's why it's important to keep your reaccreditation up.
accredited and you do want to do the course before the change occurs, we do have one coming up. I think it's in May off the top of my head, but get in touch with us and we can tell you when it is. But we're running one last one. And I know all of the organisations have been running their final ones so that people can do the assessment through NMAS, which is a little bit easier and probably doesn't add as much pressure and as much time. So if you want to get in on the end to automatically transfer over into AMDRAS, there are still availabilities. There may still be with other organisations as well. But yeah, keep your eyes open. Otherwise, it's the 30th of June, Linda. Is that correct?
30th of June. And so that means that if you get your NMAS, you have to be a pretty quick turnaround to get your accreditation as well.
Yeah,
NMAS.
Absolutely. Yeah,
Yeah.
yeah. Which is why
But
I think when I did the dates, I was like May, then they can quickly do the assessment straight after and get accredited and fit it all in.
And yes, a number of RTPs have got like extra assessment dates in, etc. at the moment. But look, if you haven't got questions now, please reach out to us at GTPD and can have a chat. But A, don't panic. B, relax. And if you're looking at advancing up the stream, just give a bit of time and then see what's out there, because you kind of find some difference in the different RTPs as well.
And I think, Linda, I obviously haven't had as much exposure to you as what you've had with all of the changes with AMDRAS. But I think what I hear every time that I speak to you about it is, at the same time, things are changing, but nothing's really changing as well. In that, in the past, when we had the RMABs and they also had registered training organisations as well, that's exactly the same as what it is now. You've got your RAPs and you've got your RTPs.
Yeah.
Yep, they've just changed names, but they still have the same role. So nothing has actually changed. Even to go in straight away as an accredited mediator, that's exactly what we have now. So nothing again changes. If you want to advance, absolutely, there's ways to advance within that. But the reality is our worlds are just going to transfer over on the 30th of June into this new way of doing things. But yeah, at the end of the day, it'll all happen automatically for most of us.
From an AMDRAS point of view, Bobbi, and to people on, the biggest changes was about re-looking at our training and assessment and getting that right. Yeah. Not that it wasn't right with NMAS, but one of the big thing was that 38 hours and you go out and become a mediator was like, oh my Lord. So the reality is that, it was more about getting that training and assessment. So for those coming into our profession, they will find a difference. At the moment, we're all, those of us who are teaching it are going, right, we're a little different here and a little different there. But by the end of the year, it will just be like what NMAS became. So, yeah.
Absolutely. I've recently been doing some training in FDR. And so now, obviously, I'm talking about, Regulation 20 and Regulation 21 instead of Regulation 25 and 28. So many changes.
And I do agree with your comment. There's so many acronyms. And yes, if I can just touch on the LMA, that I don't know how many are New South Wales. The Law Society of New South Wales decided not to continue with AMDRAS, and they've set up their own scheme, which is the Lawyer Mediator Accreditation Scheme. And that's for the Law Society of New South Wales and the Bar Association. I will be perfectly honest and blunt and say, I think if you're looking to become accredited, go to LMA if you're involved in their world. But I think it's worth looking at keeping your AMDRAS accreditation up as well, simply because AMDRAS is sort of the national body, and we know government instrumentalities. Certainly the FDRPs, the AGs will look at AMDRAS as a line in, not LMA. So just be mindful at the moment where they all sit. That's all.
Yeah. And from a practitioner perspective, I'm actually really quite excited about the level of movement that can happen with that accreditation. Instantly in my mind, I'm like, oh, how do I become a leading mediator? However, I know I need to be patient. But for me, just thinking about those levels of qualification and that growth that comes with that. But how good is that for us as professionals, where we can go through those increments, but also how good is it for our clients as well? So that when they're choosing a mediator, they can see the level of experience that people have. They can also actually weigh mediators up and choose which one is best for them and the structure that mediator has. I think it's so important. And that's the part that I really like.
Yeah.
I'm quite excited when we put together our practice certificate to actually play with that and see what it looks like to begin with, because I think even for us as trainers, it'll be so valuable to be able to embrace those discussions and that group dynamic that's going to happen. Because mediation, it's so silo that we really don't get access to others. So having that opportunity, I think, is invaluable. So I'm really excited about that. So whether you're a member or not a member, if you are interested in doing that, we will be providing further details later on once it all becomes a little bit clearer and once we've got approval, just as many other organisations will as well. So, but if you're ready to advance, just keep your eyes out. There'll be lots of opportunities for you to be able to do that. Okay. I didn't have any other questions, Linda. I thought that was really clear. If anyone does have questions, chuck them in the chat or in the questions and answers. But the big message I've got is don't panic. Everything will happen automatically. We just ride the wave and then we work out what happens after that.
That's
Wonderful.
exactly right. In 2 years' time, we won't even remember what NMAS was. It'll be all AMDRAS. So.
Yeah, we'll be like, remember back in the old days? Yeah.
Yeah, that's exactly right.
All right, so let's move on to this other big change that's very recently happened. So much chatter about this. I know I've done a lot of supervisions in the last sort of month or two where everybody's been talking about these changes and how they impact on everybody. Again, just to reiterate, we're not experts. We're just here doing our own thing and hopefully providing some guidance or some ideas on how we're thinking about these changes. So please know that don't hold what we say as, you know, the Attorney General's Department is telling you this. It's just Linda and I. Okay, so I've got a bit of a list about things and themes that have been coming through in my discussions with people. So I thought what I might do is just kind of run through some of those. And Linda, I'd love your view on it as well, because I know that in your world, you're probably a little bit more immersed in the AMDRAS side of things than the FDR side of things, when I'm probably a little bit more FDR than AMDRAS. We're both connect over into both, but I think our focus sometimes, especially with everything you're doing with AMDRAS at the moment, has kind of probably pushed you that direction. So hopefully you'll have some good questions for me as well that will challenge me and make me find answers. Okay, so, and thank you. Yes, there is already some changes on website. So I can see in there that there's a chat in there. Thank you for that, giving some information to other people about.
Resolution Institute is formally a RAP and an RTP. Mediation Institute is a RAP and an RTP. AMA, Australian Mediation Association, is a RAP and an RTP. And there's about 2 or 3 or 4 more coming through in the next few weeks. So everybody's starting to get that kind of momentum. So yes, just to clarify, yeah.
Wonderful. Okay, all right. So I guess when I went through the changes from the Attorney General's Department around FDR, a lot of them's around the pathways of getting the qualification and things like that. I don't think are going to be that relevant for this conversation, because I'm guessing that most people on here who are interested in this part of it are already FDRP. So I'm not going to touch on that unless you want us to, and in that case, pop it in the chat for us or in the questions and answers. But I wanted to talk about the practice complexities or differences that are going to happen or that have already started to happen. And I think the first one, the big one, is around the certificates. There's been so much chatter about the certificates, and I'm sure we've all been in the emails from the Attorney General's Department. We've watched the webinar that they've sent out as well, if you weren't able to watch it live. If you haven't had access to that for whatever reason and you haven't seen that, please get in touch and I'll flick you off the link. I'm sure it's somewhere on the Attorney General's Department's website, but rather than you go searching, I'm more than happy to hand that over to anyone who hasn't had the opportunity to see that. It was a great webinar that happened, I think it was on the 2nd or the 3rd of April, that kind of went through things. And then after that, there was a follow-up email because of some of the questions and answers that were in the chat in that particular webinar. So the certificates themselves have created a lot of conversation, and I've looked at the certificates and they are different-ish to what we used to have. The wording is slightly different, but I think at the end of the day, it means the same thing. I didn't have any issues with the Cert A, B, C, D, and E and the wording that comes with those. I think nothing really there has changed to any major degree. But I think the big one is around A certificate is now for one person. If the person who requests the certificate, their name goes at the top of it. They are the ones who are requesting it. So it's a one name certificate. When before we used to put all parties' names on the certificate. So now it's the one name, which then has created that level of complexity about, so where do we put the other parties' names? What happens if a party has several parents connected? I think that has created some worry, and the Attorney General's Department the other day did send out an email saying that they have written the word between at the top, but then they haven't elaborated from that. So it is a little bit of a typo that will be fixed in the future. But until then, what they're requesting is that we just name the other person, and that can go somewhere there in the matters for dispute. And I'm just gonna put it in brackets at the beginning of that section, and just write other party and pop their name there, and then start to write what the matters are in dispute. Is that kind of what you're thinking, Linda?
Exactly. I was thinking that. I think it's a good idea to have the one person, because you can issue certificates. My disappointment is we still don't have genuine and non-genuine definitions, but I'll leave that.
Yes.
It's
Next
my
time.
bag. It's my problem. But that means you can issue a certificate, the certificate to really represent what you have in front of you.
Exactly.
So my idea was that I'm just going to put Fred Smith and in the brackets Mildred Smith, and then start on,
Issues in
living
dispute.
arrangements, whatever it might be.
Yeah, absolutely. And there is a question in the chat there around, there are some services who issue certificates to both parties, even if they're not requested. If you do that, that's fine. But what you will need to do is 2 separate certificates, one to Joe Blow and one to Mary Lou. So there isn't, each party will get their own certificate. We're no longer now just sending the same certificate to both parties. So that's just that slight little change, which I guess is a little bit of extra work. What I have done, and I don't know if anyone else has cheated to some degree, but with my certificates, I've already separated them out into A, B, C, D, and E. I've got rid of, because you can strike through or delete the other clauses. So I've already set mine up where I've got my Cert A. All I need to do is go in and put the party's name, the other party's name, the issues in dispute, and the dates. I've already got my registration number in there. I've got an electronic signature in there. I've got my company name in there. So I just need to date it and put people's names and the issues in dispute.
Yeah.
And I've got that already pre-populated for every certificate. So in my mind, generally a certificate takes about probably 30 seconds to create, because I just need to fill in a couple of blanks. So now that time has doubled. So if 2 parties need a certificate, it's going to take me a minute instead of 30 seconds. But yeah, just a little tip, if no one does that and you recreate it from scratch every time, don't have it pre-populated. It'll just make your life a lot easier, trust me. So the other part with a certificate is around the matters in dispute. Remember in the old certificates how it used to just have parenting matters, I think was the wording in the old certificates. You could put some parenting issues in there if you wanted to, but it wasn't something that we needed to do. Now we actually have a space for it where they are wanting us to put something in there, and that can be general or specific. Now, when I've been thinking about this, in my world as a private practitioner, most parties come to me for mediation to get a full parenting plan. So they don't often come with 1 or 2 issues in dispute. I know there are other places where they do that. I get it randomly, but not very often. So I think if there was, say, 1 or 2 issues in dispute, it's quite easy to put the issues in dispute in brackets, other party Mary Lou, time and passports, for example. But for my clients, the list is huge. I do a full parenting plan that is probably about 7 or 8 pages long often. So what I have thought that I'm going to do is I'm going to have some standard wording, I think, for those parties who do the full parenting plan. And I haven't got this perfect yet, but I'm sort of thinking around something like matters pertaining to a parenting plan, including but not limited to living arrangements, decision-making, care, welfare, and development of their children. Something like that, that's kind of general, but that covers off vaccinations, passports, education, health, communication. It kind of covers off all of those other things, because otherwise the list would be really huge, and I would hate to miss something in the list. And then a party come back and go, Bobbi, you've missed something, and then it creates conflict. So I'm thinking of having a generalized sort of statement for those ones that are wanting the full parenting plan, as opposed to the one or two issues on their own. What's your thoughts on that, Linda?
Yeah, look, I agree with that one, and I think that's a good idea with the parenting plan. With the individuals, I used to have like co-parenting issues, not exclusive, but covering, you know,
Perfect.
managing changeover or time with. So I think you could have your parenting plan, and you could possibly have co-parenting issues, not exclusive. Bang, bang, bang. So, I
Yeah,
mean, something like that, so that you get
absolutely.
again have your template that you can just pop it in.
Yeah,
Because I remember when we first got the certificates, you know, I remember that was one of the questions, how much detail? And it is that, again, it's reflective, but it doesn't, you've got to be careful that you don't trigger off anything else. So, yeah.
absolutely. And it makes it really difficult as well when you have somebody come in for intake. I know, and I'm thinking about the Cert A or the Cert B in particular. Often if I have somebody that comes in for intake, they don't give me their full list
Yeah.
in intake because my focus is on those power dynamics that are possibly going to be present in the mediation, making sure I'm doing my assessment well. So I'm not necessarily fully focusing on give me a list in case I need to put it on a certificate. So for me, that's something that I've been thinking about as well. And I think the generalized statement, if they're wanting a lot of things, will be easier. If they're coming in just to do travel and passports, for example, that's a very different scenario. But the bigger ones, I think something to cover it all, a catch-all statement. We're just looking in the chat here. In clause basically, have not disclosed it.
Yeah, well, I would keep it very general too.
Yeah. There's a great question in here around if it is something that they haven't necessarily disclosed to the other party, then we've also got confidentiality issues as well, which is a really good point. So I think that generalization may be a good way to go forward with that. So
I think the point that that participant picked up was that certificate A, B, you need to look at very carefully.
definitely,
With
yeah.
certificate C, D,
A,
or
D, and E.
everyone's in,
Yeah.
you know, we've got them all in together, so
Yeah.
that would be different. So I think your point, Bobbi, about looking at certificate and A being different for a couple of reasons now, particularly certificate A for about intake, and you're going to talk about intake and confidentiality. I think we just got to make a note of that for ourselves.
Absolutely. And it could even be that level of transparency with parties as well, of saying, look, if it gets to the point where FDR doesn't go ahead and I do need to issue a certificate, did you want me to put specifics on there or something more general? So we need to think about how we're actually going to manage all of those things. Really, really important. But yeah, there's a few different ways to do it, and my mind's kind of going all over the place about which way is best. And I'm sure that it will grow and naturally evolve as time goes on. But that's where I'm sitting at the moment around, you know, either really specific issues or something just a little bit more general, which potentially can protect that confidentiality, or it may not as well, which is something we need to consider and maybe then talk to our clients about. Okay, so
let's just, if there's a question there, I just thought, sorry,
question that came
if you choose not to include your full name, it's ultimately the court if they decide to accept a certificate with only the first name.
Yeah. And I think that's due to the register that we are now going to be on, and they're wanting that to reflect that. And I think, so the question is around the full name of the practitioner going on the certificate. In the past, the practitioner hasn't had to do that. You could put your first name or a pseudonym, and that was more than okay. But now they are requesting that you put on your full name because you're going to be in the register anyway that's publicly available, or a pseudonym for that, which is approved by the Attorney General's Department. If you decide to put just your one name on the certificate, the court may decide to not accept that certificate because your full name isn't on it. And I guess lining it up then to the registration number may cause some complexities. So there's just here for clients getting punished for it. Yeah, and I think the question is, and I love that question, thank you for that. If the court was to reject a certificate because the practitioner doesn't have their full name on it, you know, is that doing your clients a disservice? I would probably think so. I'd be cautious of that. Because parties are often coming to you for a service, and if that service isn't successful, then they're wanting, I guess, the next step in the process, which, as we know, FDR is a mandatory component of that, for them to be able to move forward. I think if you do have worries or concerns about using your full name, talk to the Attorney General's Department about it, because they did talk about the fact that you may be able to use a pseudonym as well, which may be useful to those practitioners that are worried about their privacy. So have a chat to the Attorney General's Department if that is a concern to you. I know when I've worked in the not-for-profits, we never used our surnames. When I went out into private practice, I've always used my surname. So for me, I'm not personally worried about it at all. However, for some practitioners, it may be a thing. So chat to the AGD.
I think sometimes when I worked for an organisation, they wanted us to only use our first names. But when I was in practice, private practice, I used my full name. And
Yeah.
as I said, now the public register, they could track you down anyway through your number, if nothing else. So
Yeah. And I do agree. The comment is on here that we do sometimes work in a relatively high risk area. A lot of our clients with domestic violence and those types of things can create an environment that, there is some risk attached to that. So make decisions that are best for you. But if you do have worries and concerns, the Attorney General's Department have made it clear that they are open to having those conversations and finding a workaround for specific practitioners. Okay, so get your concern, and hopefully they'll be able to help with that. So the certificates themselves, the other thing that I think has been sort of playing on my mind around the certificates is what has sometimes happened. Some of you may not have ever done it, but just based on my understanding of sort of what people have been doing in the industry over the years is, if, for example, people have done mediation and they've put in a genuine effort and they've got agreements in mediation, and then say 3 months later they contact and say, hey, listen, it's all fallen to bits. Can I please have a Section 60I certificate so I can apply to the court? In the past, some FDRPs would issue that Section 60I certificate to those parties saying that they put in a genuine effort in the mediation and the parties have been unable to resolve their dispute. Yeah. In the fact sheet, though, that comes with the certificates, in the past, it had clearly written in there that if FDR had full agreements, that we're not to issue a certificate. But I think there had sort of been people doing that anyway, as opposed to making people come back through the FDR process. I just by talking to people, I do know that has happened for some people. So if that's brand new information to you, please don't listen. It's not relevant to you. But for those people who have been doing that in the past, it is back in the fact sheet, and it's a little bit more in depth than what it was before. So now it says that a practitioner should not issue a certificate where parties come to an agreement in relation to all of the issues in dispute, as they do not need one. So a certificate from FDR, if there are full agreements, no longer exists. As I said, some people were doing it as long as it was within that 12-month period and kind of doing a little bit of a workaround. They shouldn't have been, but that was happening. So going forward, though, it's important that that doesn't happen anymore. And for those of you that had been doing that in the past, I think it's about making sure that our clients are aware of that as we transition them out of the mediation process. So if you are doing a session and clients get full agreement, and then we talk about where to from here, and we talk about parenting plans and consent orders, at that point, we also need to talk to them about, so if there is any issues with the agreements that the pair of you have made today, the next step for you would be to come back through a mediation process. Because you've made full agreements today at mediation, there isn't a certificate that you are eligible for. So please come back through the mediation process should there be any issues. Okay, so we need to ensure that clients, and I know even some solicitors have requested certificates during that 12-month period, even if there had been full agreements. So please be aware of that. On the fact sheet, which is on the Attorney General's website, it's that one, don't mind my highlightings. It's on the back page about halfway down, so that pink highlight there. So just be very mindful of that. For some of you, that may be something brand new. For other people, they may have been doing it anyway. So please bear that one in mind. So there is something in here, note in the chat, saying that there are some organisations that will provide a Section 60I certificate even if full agreement is reached. Yep. So that is the people that I'm referring to that have done that in the past. However, it clearly states now, and I think with these changes now we need to all really step up and adhere to all of the changes that are happening. And it clearly states it on the fact sheet that you're not to do that. Under any circumstances, a certificate is not available to people who make a full agreement in mediation. I do understand that that can create some complexities for parties in that, they may wonder about whether or not they should agree to something because we're really hypothesizing whether something's going to work or not. And in the private world, people will often have to repay for mediation, which at times can be thousands of dollars. If they're going through a not-for-profit or a government organisation, there's a time factor that comes with going back to mediation. So I think that there are some downsides to not being able to issue a certificate and making people go back through the mediation process. But we've been instructed that we're not to give a certificate, so we just need to let our parties know that. But I think reassuring them about why they've agreed to what they've agreed to and hoping that they're okay with that, but also knowing what the next step is in the process, which is coming back to dispute resolution. You can't automatically move through to court. The other thing that I did think about with it was maybe, is it also about some clever wording for certain people who are a little bit unsure about whether or not they completely agree to something and that there might be issues. And that might be some clever wording in that, and I'm just thinking off the top of my head, so don't use this wording in itself, but something like, the parties have made a partial agreement in relation to this area, and if it works under this review period, we'll enforce it as a full agreement or something like that. As I said, I'm thinking off the top of my head with that wording, so don't use it. I'm sure I can do better. But something like that. So that way there, I guess, it's not full agreements in mediation and still opens that door should parties wish to go down that path. Because we have some people who go, oh, yeah, that could work. I think that might be okay. I'm happy to agree to that today. But you can still see that they're a little bit unsure about whether or not it's realistic for their children and actually in their children's best interest. And I worry about those parties that they might get sort of pushed out of getting it resolved because they can't afford to go back through private mediation or they can't wait to go through one of the not-for-profits or government organisations and courts removed from them. So just some of my thoughts on that. Linda, do you have any? Oh, Linda, you're muted.
See, I coughed. But yeah, I mean, I think that whole thing about certificates being issued after agreements and things, I always had concerns about that because to me, yeah, anyway, I think now it's just reinforced. As I said, I think some organisations do that as a matter of course, and some private organisations. To me, it just adds a proper level of practice. And, and I mean, if they ring up 2 weeks, well, that's different to ringing up 3 months, as you said, or 6 months, because then you can start the process again to see where you're at.
Absolutely. And I think that reality testing with our parties in mediation is so important to make sure that when they are agreeing, they're actually agreeing. And as I said, if they're a little bit unsure, maybe we need to use some wording to keep the doors open for them if that's what they want.
Well, that's what you need in your agreement, good boilerplate clauses, a good, about conflict resolution, etc. I always thought, and this is just personally me, that it was sort of going, well done you, but just in case.
Yes.
And like, you can't do well done you, but just in case. To me, it's either well done you and let's keep working, or okay, guys, you did a good attempt, here you go.
Yeah. And it's been made very clear. And I think and I've noticed that clause in that fact sheet over the years. But when you talk to people, real world practice is slightly different. But I think we've got so many changes that are happening at the moment. I think it's time for the profession to all get in line and follow everything the way that we should be following it. So it's an opportunity to create big change.
To me, it's just the role of us. I can't, that if somebody gets an agreement, all right, if something happens, I want them to ring me first, particularly if it's a complaint or if they got some problem, and then we can try to work it out. But if you give them a certificate, they'll just go on their merry way, and we don't really know. I mean, we don't know what happens to a lot of our parties anyway, but you know what I mean?
Yeah.
To give, and so, yeah, so I think it does have a couple of advantages that you
100%. Yeah, agreed. Yeah. But for those of you that haven't been doing it as, I guess, as standard, you're going to have to think about how you maneuver that in your new world of all of these changes. So just something for you to think about. For those of you that had nothing to do with, you keep doing you, well done. So that was pretty much the things in the certificates that I found that were a little bit different, a little bit, I guess, interesting in needing a discussion, or I've spent a lot of time thinking about those particular areas of certificate. So if you've got anything else that I've missed, please pop it in the chat or in the Q&A, and we can go back to that. But just moving along, the other thing that I think is great and a wonderful positive change is the fact that now we actually have a time frame of keeping our records. That was a little bit all over the shop. No one knew what the right answer was. It was just, securely store your documents. But retaining our records now for 2 years, I think is really good. For myself, I've got records from the very beginning because clients come back and they don't necessarily come back within that 2-year period. And I want to be able to refresh myself of the client's cases and, even just that rapport building of their names, of their children and things like that. So I keep my records probably forever. But I think having that 2-year period, I think, is really important, not just for us, but also for our clients if we do need to pick up where we left off. So, yeah. Any thoughts on that one, Linda?
Yeah, because I'm the destroy after a month girl.
I know.
So I'm going to create the document similar to what I have at what RA, a good summary that I can put my notes in and things like that, so that I will have that documentation that I will keep for 2 years. I think it's great when you have returning parties. My concern, and you're going to touch on the complaints and all of that, it looks like you've got to, have that complaints could be up to 2 years, that kind of thing. I have quite a problem with that in terms of people will complain about different things along the journey. And so things that to do with the mediation are like, within 6 weeks but if somebody starts complaining about something 12 months after the mediation, is it directly to do with the mediation or is it consequences of the actions? And I think I'm on a bit of a roll on this. I'm hopefully getting paper up on NMC about it, because I think we've got to be mindful that we're talking about what's beneficial for our clients, but what's also beneficial for our practitioners. But the 2 years, we're all going to live with that. So I agree, as much as I don't work or don't used to not work with, at least there's clarification. Before it was like, keep them secure. Thanks. What, where and how and why and when.
I used to always, when training, and I would be like, and that people would ask about it, and I would go, you just have to keep them secure. We don't even know what they are, but just keep them secure in some way. So at least there is clarity, which I think is really important. But I did chuckle when I first read it, and I knew, Linda, you're the 30-day person. So I did chuckle for you, and I'm the forever person. So we're at each end of the spectrum.
Well, worse, we've got colleagues who are on the day person, so they're going to be really in problem.
That's right. Yes. And there is a question in there about what details are they looking for us to keep and what can be destroyed. Again, there's not a lot of clarity in that. It just says that the exact wording is, let me find it for you, that they need to be kept for 2 years. Hold on. Where is it? I've got it here somewhere. Here. Under the new regulations, you must securely store family dispute resolution records, including case notes and files, and retain them for at least 2 years. So in an FDR session itself, my scrap notes that I write little reminders for myself on, they get destroyed, and they always have. They're useless to everybody. They mean nothing. They're not a case note. They're a reminder for me. Somebody might say, the green Ford, and I'll write down the green Ford so I remember to come back to it. But when I think about sort of those case notes for retaining, it's your intake, it's your agreements made in mediation, it's your agreement to mediate document. It is your invitation letters. It's your emails between the clients organising mediation. So those sort of admin as well as information gathering from clients would be what I interpret as those case notes and documents. What about you, Linda?
No, exactly right. I will not still keep my, because I'll write down a word,
Yeah,
and
same.
so I will throw that out. But as I said, I already keep, even though I say I throw my notes out, I already keep the agreement to mediate, the agenda, any agreement they get, all the admin stuff on the back end.
Yep.
Well, what I will probably do is do what we did at there would be a case summary.
Yeah. Yep.
It's a brief case summary that I'm happy for them to have, me to have. It's a documentation. I don't care. It's I will destroy my notes, my handwritten, because nobody's going to read them, A, and
Yep.
B, the practice that we did have at RA when I worked there, we brief summary that put it in there. They used to get kept, they're still being kept forever. To me, that I'm going to use that as my case notes.
And just an example of a brief summary after FDR, Linda, might look something like the parties made a genuine effort in the mediation process. Full agreement was reached or partial agreement was reached on these areas. Areas that had not yet been agreed upon are ... Just so that way there, you've got that information as well in case you need to do a certificate as well.
Exactly. My case notes is agenda, agreements reached, issues still in dispute.
Yep, that's it.
Yeah.
Yeah, no opinions, none of that stuff, because we know that they
Nothing.
don't go into case notes at all anyway. So very practical information. Again, thinking about the certificates that we're going to have to issue where we actually need to put the issues in dispute on it.
Yeah.
The other thing with the admin is please know that that also means domestic violence orders and those types of documents as well. We're just talking about if you've got a handwritten note to remind yourself of something, we're getting rid of those, but everything else that is important for the file will be kept.
Question about intake documents.
Intake documents with confidential information too. Yes. So I keep my intake documents because that is part of my case notes for the file, and that is what I use to do my assessment on.
And that's why it's important to have intake documents that are consistent. So not just that's why those of you I ever taught, and there's a few people there, you create your template. And so that's the document that looks exactly the same. Yes, there's slightly different what you filled in, but you don't have long explanations. You just got your intake based on what you needed for information gathering and assessment. I'm just bearing in mind time.
Yes. I could talk about this for ages.
I know,
okay,
you're so excited.
Couple more things. So that case note keeping, I think, is really important. I also love the CPD and keeping our records for 7 years. I think that that's really important. The other part of the CPD that I really loved was the fact that during that 24-month period, we have to complete 24 hours of CPD. That's fine. I love the fact now that it has to include something to do with domestic violence. Yes. For me, that is so, so important. Often CPD doesn't include that, but the domestic violence is so prevalent in our area that I think making sure that we are up to date, we are very aware of it, we know what's going on, we have the skill and the ability to be able to manage it well, I think is brilliant. Well done, Attorney General's Department. I'm so happy about that. And for our members, there will be additional resources for you this year. In our list of webinars that we've done, there was nothing specific to DV, so we will pop another one somewhere in amongst all of that so that you can tick that box.
And it'll be standard for us, Bobbi. I'd say we'd have that
100%.
Every year.
Absolutely.
Someone brought up about intake. That's the thing that I think you're going to touch upon anyway. Is that yes, intake is very clearly now going to be covered by confidentiality if you're done by a registered FDRP, and if it's not, I'm sorry.
Absolutely. And what had happened in the past, and I'll move on to that because that was my next part.
Sorry,
no, it's brilliant. And thank you.
I think that we had a question about property and intake, so yeah.
And I'm loving that the questions are sort of sending me to where I was
going.
Anyway.
So, going where you want to go, yeah.
So that tells me that maybe it's flowing well. So with intake, and I love the fact that that is now clear for FDRPs. In the past, it was that grey area. it was black and white, but still had slight grey in it, where we were just a little bit cautious. What I like now is that we are guaranteed as FDRPs, if we do the intake, that they are now covered. We don't have to worry about confidentiality. Our process is then confidential. If you are not an FDRP and you are conducting intakes, it's not confidential. You very well may not be subpoenaed, but you very well may be. So I think having that really clear distinction makes it easier for everybody to go about their jobs. I know in training when we would talk about it, and as soon as we mentioned Rastel and Ball, everybody would go into panic and everybody would way overthink it. And I was saying to somebody the other day, so we've got the one case. I can't even imagine how many FDR cases have been conducted in the last, 19 years. It would be probably hundreds of thousands, and we've got one, right? So when you put it into perspective, it really wasn't that big, but at the end of the day, it creates a level of grey and creates caution. So I'm really happy of the fact that FDRPs, our intakes are now covered. We don't have to worry about it. If you are not an FDRP and you are conducting an intake, it's not covered. There's no guarantee of that being covered. And I really love the fact that that's really nice and clear now. I also love the fact that now the FDRP is and has to be the person who makes that assessment. Before, that too was a little bit grey. That wasn't really clear about who's making the assessment. We all know it should have been an FDRP because we have the qualifications to be able to do that. And it did say it in Regulation 25 back in those days, that an FDRP needs to consider, but there were a lot of organisations who weren't doing that, where instead the intake person was making that assessment. So even if you now work in an organisation where intake is being done by one person, the FDRP is now responsible for ensuring that assessment has been made according to our regulations, which I think, again, just that level of clarity makes me feel really confident in the role that I am doing as an FDRP. Your thoughts, Linda?
Yeah, no, I was so happy to hear that, because basically you'd always put like, well, this is confidential and that I won't take it to the other party, but we didn't really have that. And I think what, and I'm not trying to anticipate what the age is, but I think it's also about best practice. I know a lot of people are going to disagree with me, but if you have the opportunity to do the intake as well as do the mediation, it does make flow better. Though I have had some wonderful people do intakes, and I know a lot from that too. But look, it just makes it so much easier for us to go confidential. Then we've got that umbrella. That's for me.
Yeah. And I used to do the two different spiels. At intake, I would do one confidentiality spiel, and at FDR, I would do the other one. Now I can just do the one spiel across the board, which is really nice. There are a couple of questions here about supervising. If an FDRP is supervising a student to conduct the intake, I do think, and I could be wrong, but I think I have heard discussion, and I'm not sure if it was from the Attorney General's Department or just sort of around the traps, where getting the student to sign off on confidentiality, that they are there in a confidential setting, but it's the FDRP that is taking responsibility for the regulations. I feel like that was chatter. Did you hear anything about that, Linda?
No, I didn't, but I would go with my gut to say, from being working in the FDR, any kind of placement, the student can't sign off on documentation anyway, so they have to be supervised. So it's the FDRP that will be signing off on any documentation anyway. So
exactly.
A student, like a placement student who's doing their 20 or 50 hours, it's going to be the FDRP that falls back on. Therefore, it falls under the FDRP. Yeah.
And it's the same, I guess, if you think about FDR in the past. If we had a supervisee in the FDR, we never worried about confidentiality with that, because it was our confidentiality that was the important part of it. So I think it transfers over now into intake. And just as if I've ever had a student in with me, I get them to sign off on confidentiality anyway, so that way they adhere to that.
To me, they're like the party. They've got to sign off on the whatever said is confidential. So
that's right.
and I think it just puts that extra onus on them.
Yeah, definitely. So just watching the time. So just one last area that I want to touch on.
We can't stop her.
I know, sorry, was around complaints.
Oh,
And
yes.
I think that has, and I've seen chatter out there where everybody's starting to sort of worry about, oh my gosh, I need to have a complaints body, and what if mine isn't doing a complaints thing anymore? How am I going to manage all of that? I feel like, and Linda, please correct me if I'm wrong if you have a different view, but I feel like that's also like the AMDRAS stuff. Let's just watch it play out. I'm going to assume that a lot of the old RMABs that are now RAPs, did I do well? Yes. I'm guessing that a lot of them will actually become registered as complaints body with the Attorney General's Department, but there's just paperwork that needs to occur. Some may not, but they'll instruct you.
Yeah, look, there's 6 months grace. There is a lot of paperwork because there's a lot of questions about the process, about that. So, and there's that list of lists that are on. That list will be confirmed, updated, changed within 6 months.
Yeah.
I'm involved in working with one of the complaints bodies, getting their mechanism right, because they've asked a lot of questions about how you would deal with it, what kind of sections. So they're wanting a definite framework. But we have 6 months. So if RI is your complaints body, for example, that's not going to be changed. They will let you know. They will tell you whether or not they can or can't or whatever. So if you've got an email from them already that they said, yes, we're going to be that, or if you've got an email saying we've got to look around, that's fine. But you have 6 months grace. So it's their responsibility to let you know, and I know they are. But give them a little bit of time because they have to create these documents. I know for a fact.
And I know that there's been some, I guess, fear generated that I've been watching on social media. So just everybody just breathe. It's the transition, and there's a lot of paperwork that needs to be done before anyone can actually go, yes, we're a complaints body. GTPD isn't going to be, just to be very clear. However, but before anyone can put their hand up and say, yes, we've got authority to be able to do that. So just breathe, everything will be okay. And one thing I love about our industry is that there is so much information and everybody shares it all. And I think that makes me feel really secure that I'm not going to miss anything as time goes on. So I hope everybody else feels somewhat reassured with that as well.
And look, just give it time. And look, the AGs have been very responsive. After that, they send out a frequently asked question. My understanding, and I've had a number of meetings with the AGs in various of my capacities, they're very responsive. They will tweak things as they get feedback. As it does, they will tweak it as necessary. So let's just chill. It will all happen. Business as usual, except for some of us, we've got to remember to keep notes. So that's about all from my point of view.
And I've got to change the regulation numbers in my head.
That's okay. I'm pleased with 20 and 21. It's much easier for teaching purposes.
20, and just a quick opinion before we finish up. Regulation 20, I love the undue influence, the additional clause in that, in Regulation 20, which is our assessment tool. I think that's absolutely fantastic, because in reality, there are other things going on in people's outside world that affect their capacity to be able to negotiate freely. So I loved that part of it. So if you haven't seen Regulation 20, which is the old Regulation 25, have a look at it. The clauses are a little bit longer, but meaning the same thing. But there's that one beautiful additional one, which I think is going to be really helpful. One other little thing that I did, I keep saying one thing, the Attorney General's Department, they reminded me when I went to the webinar the other day, make sure you've updated your details on the register around your NMAS accreditation or AMDRAS accreditation, as well as your complaints body as it sits today, because that was a mandatory component anyway. They need those updated on the register. I've updated mine. I did it the other day, and they were most helpful to help me to do that. So get on, check what you've got on there, but you need to update that documentation as well to keep your registration.
Yeah, and just the wording can be a bit, because I talked about complaints certificate. And there's some organizations doesn't have a certificate, so just get the email from them and that's fine, and update your insurance. And I did it too, except I didn't update my certificate because I didn't know what a complaint certificate was, because it didn't exist in my world. So it's okay. So and you'll need to do that annually with your insurance, for example. So,
Absolutely. Yeah. But get on and check what details they've got of you and make sure they're all up to date. Because now it's going to be a very transparent process, and a very easy way for people to be able to see us in our profession and have access to us, which I think is wonderful.
Well, we've taken people's whole lunch hours up.
Sorry,
Really,
but hopefully it was worthwhile. I enjoyed it. I hope you did as well. So thank you all. I will just quickly pop up, give me a second, just some further details about us if you haven't come across us in the past but came across this webinar. So our organisation, we offer a lot of different things to assist mediators and FDRPs. So there's a range of things that we offer. And we also do masterclasses every year in a range of topics. So we have those which will help you to go towards your CPD points as well. So thank you all. I hope that that was helpful, and I hope it provided some level of clarity to all of these changes that are going on. And I have no doubt there'll be further webinars around the changes, Linda, as they do progress.
Exactly. Yeah.
And thank you everyone for your participation. It was very helpful. Take care. Thank you.
Okay,
Bye.
have a good one. Bye all.
Bye.